Motion passed. Statute Law Miscellaneous Provisions Bill 2024. This Council now becomes Committee of the Whole Council to consider the Statute Law Miscellaneous Provisions Bill 2024. Members may refer to Appendix to the script for the debate and voting arrangements for the bill. Members have been informed that the committee will conduct a joint debate on the clauses, schedule, and amendments. I now propose the question to you that the following clauses and schedules stand part of the bill. Clauses 1 to 116 and schedule. Secretary for Justice will move amendments which seek to delete Clause 59 and amend the schedule. Members may refer to the appendix to the script for details of the amendments. Members may now proceed to a joint debate on the clauses, schedule, and amendments. I'll first call upon the Secretary for Justice to speak. But he's not required to move the amendments at this stage. Then I will call upon members to speak. Upon the conclusion of the joint debate, the committee will first vote on the clauses with no amendment, standing part of the bill, and then vote on the amendments. Secretary for Justice. Chairman, I now move 3 amendments to amend Clause 59 of the bill and Part 47 of the schedule to the bill. The detailed amendments are set out in the paper sent to members by the Electoral Secretariat. I will now outline the amendments. Clause 59 of the bill proposes repealing Section 21 of Schedule 8 to the Interpretation and General Clauses Ordinance Cap 1, because with the adaptation made by this bill of the saving provisions of 2 private ordinances, there will be no more laws requiring adaptation with phrases warranting interpretation based on the substitution principle set out by Cap 1. Some members of the Bills Committee were concerned that this change may create gaps given the great number of Hong Kong laws. These members urged prudence. They suggested keeping Section 21 of Schedule 8 to Cap 1 as a catch-all provision. Having heard this idea, the government agreed to retain this section in the schedule to Cap 1 for now. Part 47 of the schedule to the bill proposes amending Regulation 42 of the Merchant Shipping Minimum Passenger Space Regulations Cap 369E by replacing a reference to the coast of China with one to the coast of the mainland through adaptation. Some Bills Committee members were concerned that this change failed to cover the ports of Macau, leaving the law prone to legal loopholes and disputes. To ensure clarity and completeness of the provision, these members invited the government to consider repealing the reference to Hong Kong, the coast of China, Taiwan, and replace it with the term China. Other members raised a point about the reference in Regulation 40(2) to the Chinese name of Laos, Liu Guo, and pointed out the name Lo Wo was currently adopted by the Ministry of Foreign Affairs of the People's Republic of China. Having considered the facts, BC members' concerns and suggestions, the government agreed to move an amendment to revise Part 47 of the schedule to the bill. This means repealing the reference to Hong Kong, the coast of China, Taiwan, Vietnam, Cambodia, Laos in Regulation 40(2) of Cap 369E and replacing it with the phrase China, Vietnam, Cambodia, Laos, where Laos was referred to as Lo Wo in Chinese. BC members had no objection to the amendments above. I urge all committee members to support these amendments. Ms. Carmen Ken. Thank you, Chairman. I speak in support of the amendments moved by the S of J in relation to the Statute Law Miscellaneous Provisions Bill 2024. I would like to talk about Part 47 of the schedule. It is in relation to 369E, Section of Regulation 40(2), so as to use Noi Day to replace the terms. That's the original proposal of the administration. We may not be able to cover the ports of Macau. This may give rise to loopholes or disputes. To ensure completeness of the provision, members invited the government to consider the following proposal. That is, the reference to Hong Kong, the coast of China, Taiwan should be repealed and replace it with the term China in Regulation 40(2). I believe that this is right. According to Cap 1, it has already defined China. China means the People's Republic of China. For People's Republic of China, it has been clearly defined in Cap 1. The SAR of Hong Kong, SAR of Macau, Taiwan, and the mainland. But then from Regulation 40(2), in our laws, there are still statute law to put Hong Kong, the coast of China, and Taiwan to be referred to in the same breath. Therefore, at a meeting of the Bills Committee, I put a question to the administration. I wanted to know whether elsewhere in our laws we have got a similar reference. The administration told us that they had to consider the original legislative intention of the bill as well as the actual circumstances before they can come up with an amendment. And then the progress of individual amendment exercises would vary. I also said that for Regulation 40(2), the reference to Laos, well, in fact, for our Ministry of Foreign Affairs, Lo is the Chinese rendition of Laos. So I will urge the administration to make sure that we draw reference from the reference materials of our national government. I welcome the CSAs proposed by the administration. In any event, Mr. Chairman, the Law Reform Commission, as well as the departments and bureaus of the government, in relation to the current exercise, as well as the CSAs, they have put in their best. In future, I hope they will expedite their study and move forward quickly. And it is hoped that for every term of the LegCo, there should be 2 such exercises. And then for anything that will cross departments or bureaus, there should be a better mechanism so that there won't be any obstacles as a result of the lack of coordination. I support the CSAs, Mr. Chairman. It shows the commitment and the pragmatic approach adopted by the administration. Ms. Maggie Chan. Thank you, Mr. Chairman. I support the CSAs proposed by the SJ. This is responding to the views of myself as well as other members of the Bills Committee. Terms, phrases, and definitions are to be amended. First of all, Clause 59 of the bill will be amended so as to keep Section 21 of Schedule 8 to Cap 1, so as to make sure that we still have a catch-all provision, so that we can still adopt the principle therein to interpret the relevant provisions. It is right. Well, Section 21 of Schedule 8 to Cap 1 can be regarded as a catch-all provision so that we can protect our rights according to the law, according to the Constitution. As I said in my speech upon the resumption of the second reading debate, I think this bill starts the work of decolonization of our laws and rules. There are 23 other items that have been identified, and they have to be decolonized. Other subsidiary legislation is also being studied. Now, for decolonization of our laws, it is an unfinished task. The government is systematic in identifying the areas requiring decolonization. I think this is a long-standing piece of work, and we should work hard and be persistent. I think during the deliberation, myself and my colleagues have said that for rules and laws that have to be decolonized, we have cited many examples. I myself have said that for Cap 1, in relation to Schedule 9, we have still kept the word Gunfong Crown, and it is said that it should be regarded as the reference to the nation. But then for the postal ordinance and the immigration ordinance and the water pollution control ordinance, as well as the water pollution Control Ordinance, Section 8, 10, etc., all such are to be amended. I think the administration has already amended Crown to be read as SAR government. In other words, it shows that there are still a large number of items waiting to be decolonized. Therefore, it is but right for us to keep Section 21 of Schedule 8 to Cap 1. We mustn't allow the CPG and the Hong Kong SARG's rights as provided for by the laws. We must keep the catch-all provision. Before decolonization is completed, we must make sure that the rules and laws are in line with Article 2 as well as Article 12 of the Basic Law, so that we have the unitary system. And in fact, all our powers come from the CPG. We are not an independent entity. Well, in fact, our powers come from the authorization of the CPG. I so spoke in support of the SJ's amendments. Does any other member wish to speak? If not, I will invite the SJ to speak again. Secretary. I put the question to you that the clauses with no amendment as set out in the appendix to the script stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of the members present. I declare the motion passed. We now vote on the amendment. Secretary for Justice, you may move your amendments. Chairman, I move the amendments set out in the appendix to the script to delete clause 59 and amend the schedule. I propose the question to you that the Secretary's amendments be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of the members present. I declare the amendments passed. As the Secretary's amendments, including the amendment to delete clause 59, have been passed, clause 59 has been deleted from the bill. Schedule as amended. I now put the question to you that the schedule as amended just read out by the clerk stand part of the bill. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of the members present. I declare the motion passed. All the proceedings on the Statute Law, Miscellaneous Provisions Bill 2024 have been concluded in Committee of the Whole Council. Council now resumes. Secretary for Justice. President, I now report to the Council that the Statute Law Miscellaneous Provisions Bill 2024 has been passed by Committee of the Whole Council with amendments. I move the motion that this Council adopts the report. I now propose the question to you that the Secretary's motion be passed. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of the members present. I declare the motion passed. Third reading. Statute Law, Miscellaneous Provisions.